In the previous lesson, we talked about the first instance in which we can make a claim for voluntary manslaughter, which essentially reduces liability through the operation of a partial defense. In this lesson, we're going to talk about the next major method by which you can utilize this reduction in liability, essentially, moving away from looking at diminished responsibility to this idea known as loss of control. So, again, this is a partial defense for the crime of murder, which then reduces liability to manslaughter. Again, the justification for this owes really and mainly to the sentencing requirement that exists for judges when it comes to successful convictions of murder. So in a successful murder conviction, there is a statutory requirement which essentially is imposed on judges that require a minimum of a life sentence. Whereas when we talk about manslaughter cases, there is a requirement that life sentences are a maximum. And so as a result of which, the satisfaction of a partial defense, and therefore the reduction from murder to voluntary manslaughter at least, can essentially give a judge a bit more discretion in terms of sentencing and what to do about sentencing. So loss of control is one of the ways in which you can prove this. It is a it is a defense, should I say, a partial defense, which replaces the old defense, which used to be called provocation. Now, it's relatively similar in terms of the general aim and the gist of what this defense is trying to get at, in the same case as that of provocation. And it is also outlined in statute, specifically Section 54 of the Coroners and Justice Act from 2009. And Section 54 of the Coroners and Justice Act says the following. They say that where a person, D, i.e. where a defendant, kills or is party to the killing of another, a victim, the defendant is not to be convicted of murder if the defendant's acts or omissions in doing or being party to the killing results from the defendant's loss of self-control. And B, the loss of self-control had a, quote, qualifying trigger, and C, a person's a person of defendant's sex and age with a normal degree of tolerance and self-restraint, and in the normal circumstances of the defendant, might have reacted in the same or similar way. You can see here the similarities between the loss of control defense and the diminished responsibility defense, because what loss of control is getting at is somewhat similar to that of diminished responsibility. With diminished responsibility, there is a requirement of a recognized medical condition, which essentially impairs the ability of the defendant to act logically and rationally and to have self-control. When we talk about the loss of control defense, there is an act or omission is done as the result of a loss of self-control. That is the first requirement. The second requirement is that this loss of self-control has a, quote, qualifying trigger. We'll get to what this qualifying trigger means in a minute. But ultimately, essentially a justification which is recognized in law as being valid for this particular partial defense. And then finally, you then have to judge the actions of the defendant on the basis of their sex and age. So somebody who is roughly the same age as the defendant and of the same sex as the defendant, given a normal degree of tolerance and self-restraint, a general reasonable amount of tolerance and self-restraint, in the same circumstances of the defendant, would they have reacted in the same or in a similar way to the defendant? So essentially, this is a requirement for an ordinary person test, if you will, or a person, or a standard of a person of a similar characteristic as the defendant in similar circumstances. Would they have acted in a similar way, or even in the same way? Let's begin with the first of these issues: the loss of self-control. The components are the loss of self-control itself, the fact that this loss was caused by a qualifying trigger, and then whether or not this the qualifying trigger and the loss of self-control fits into what we would reasonably expect of a person of a similar characteristic acting in those similar circumstances. It must be shown that that the loss of control and the qualifying trigger are both present, and then it is up to the jury to make a determination about whether or not it was the qualifying trigger which resulted in the loss of control. So you must show loss of control. You must show where this loss of control comes from as a defense, so i.e. the qualifying trigger, and then the jury has to make a decision. Did this qualifying trigger reasonably cause the loss of control? Was there a reasonable amount of causation in this particular regard? Section 55 of the Act says the following. I'm not going to read all of it because I'm only focusing on the specific elements relating to the qualifying trigger. So Section 55, subsection 2 says a loss of self-control had a qualifying trigger if subsection 3, 4, or 5 applies. So essentially, if you are the prosecution and you have been given a defendant who is charged with murder, and the defense is arguing for voluntary manslaughter by way of loss of self-control, they will present a trigger. They will have to present a qualifying trigger which causes this the loss of self-control. Now, in order for this qualifying trigger to be justified, to be justified by law, it has to fall within subsection 3, 4, or 5 of Section 55 of the Coroners and Justice Act. Subsection 3 says that this subsection applies if the defendant's loss of self-control was attributable to the defendant's fear of serious violence from the victim against the defendant or another identified person. So the qualifying trigger for loss of self-control in this regard would be fear of serious violence. So if the defendant fears the victim is going to be seriously violent and could potentially kill or cause serious grievous bodily harm to the defendant or another identified person, then this is the qualifying trigger that represents the loss of control in terms of the killing of the victim. Subsection 4 says that this subsection applies if the defendant's loss of control was attributable to a thing or things done or said which constituted circumstances of an extremely grave character and B, caused the defendant to have a justifiable sense of being seriously wronged. Very, very vague. Subsection 3 is quite nice because it gives us what is reasonably understood to be quite an easy to understand qualifying trigger. The idea of a serious fear of violence coming from the victim. But subsection 4 talks about things said or done which are of an extremely grave character and caused a justifiable sense of the defendant being seriously wronged. Now, subsection 5, which is the final application, simply takes a combination of the two. So in their most unique form, you have subsection 3 and subsection 4, which are the most important. Let's see how some of this is actually applied in the case law. And we can begin with the case of Crown versus Jewell from 2014. In this case, the defendant had driven to the house of the victim, and the reason for this, they drove with a particular reason, was said to be to pick them up for work. Okay. Now, a number of things takes place, which ends up with the defendant shooting him with a shotgun at point-blank range. So, of course, not the most successful of pickups ever. The defendant argued that he had the partial defense of loss of control. So, given this fact, you have to then think, okay, well, what's the qualifying trigger? Did the qualifying trigger lead to the loss of self-control? And would, given all the circumstances, given the qualifying trigger, given the loss of control, is this what a reasonable person of a similar characteristic to the defendant would have acted in these circumstances? What they said, the Court of Appeal said, was that the idea of loss of control relates to, quote, the loss of the ability to act in accordance with considered judgment or a loss of normal powers of reasoning. Okay? So in a similar way to the previous defense of diminished responsibility, we're talking about an impairment of the normal powers of reasoning, if we're going to use the language of this particular case. But rather than that being caused by some medical condition, a recognized medical condition in the case of diminished responsibility, In the case of loss of control, it is the loss of the normal powers of reasoning caused by a qualifying trigger. And the qualifying trigger is either the fear of a particular of violence against you or against another individual, another third party, or the idea of the acting with an extremely grave character. Okay. Another case here is the case of Crown versus Clinton from 2012. In this case, we have the defendant who was married to the victim, where he found out that the victim has been having an affair. Okay, so the victim isn't a particularly pleasant individual. Now, upon hearing this news, the defendant suggested that he was going to kill himself. To which the victim responded with the following quotation that he did not, quote, have the balls. So not only is the victim having an affair, but then is acting and responding in a particularly unpleasant way to a potential violent response by the defendant, suggesting that he doesn't have the courage, essentially, to kill himself. In response, the defendant doesn't kill himself; he kills his wife by beating her over the head with a baton. Again, nothing about this particular case is pleasant. Now, at trial level, the judge found that the evidence of infidelity was not admissible under the provisions of the Coroners of Justice Act and Justice Act Section 55(6)(c). So, the question of trying to utilize loss of control, the judge found that the evidence of infidelity could not be used, essentially. It was not admissible for that particular question, suggesting that infidelity can't be a qualifying trigger for this for the use of loss of control. Now, what the Court of Appeal did was correct this and order a new trial. They argued that sexual infidelity could be admissible in establishing the context for a qualifying trigger. But they also made it clear that this does not mean that sexual infidelity was in and of itself a qualifying trigger for the loss of control. See, what the trial judge had done is essentially come to the conclusion that infidelity was not a qualifying trigger for loss of control, which is true, and which the Court of Appeal agreed with. But in doing so, in coming to that conclusion, they then said that any evidence whatsoever relating to this sexual infidelity was inadmissible, and so therefore could not be heard by the jury. But what the Court of Appeal said was, while the trial judge is correct that in and of itself sexual infidelity cannot be a qualifying trigger, cannot be the qualifying trigger, it could still be admissible for establishing the context for what could be a qualifying trigger. So it might not be a qualifying trigger in and of itself, but it might contribute to the establishment of a qualifying trigger. This is quite interesting, because what this does is, first of all, it tells us that sexual infidelity is not a qualifying trigger. So if your significant other has an affair or cheats on you, okay, you can't then kill them and then make an argument for loss of control. Okay, you have to be a bit more than that. You have to do a little bit more than that. In addition to this, it does still say that you can use this evidence to try and establish the context for a qualifying trigger that could be valid, essentially. Finally, then, let's look at the case of the Crown versus Ashmelash from 2013. In this case, throughout a long process taking place over a long period of time, the defendant had been regularly taunted by the victim. And then one day, when the defendant was drunk, he decided that he had had enough and decided to stab the victim, which resulted in their death. Now, the question for the court was whether or not the voluntary consumption of alcohol was a factor which ought to be taken into consideration when thinking about Section 54(c) of the Coroners and Justice Act, i.e. the level of tolerance and self-restraint requirement. So the idea of essentially contextualizing the defendant's actions in relation to a reasonable person of similar characteristics, of similar tolerance and self-restraint, being put in those circumstances. It was held that the concept of loss of control, which was one which has to be approached without taking into consideration the voluntary intoxication of the defendant. Ultimately, we have a defense for crimes, which is that of intoxication, voluntary intoxication as well as involuntary intoxication, and that is very limited in terms of its ability to absolve an individual of criminal liability. Involuntary intoxication is far stronger, but it's far rarer, of course, and so therefore it cannot be taken into account when approaching issues relating to loss of control. In this video, what we're going to do is move away from looking at voluntary manslaughter, i.e. the cases where we can satisfy a partial defence, either through diminished responsibility or even through loss of control, and they're now going to start to talk about some of the more involuntary forms of manslaughter. We're going to begin in this video by talking about unlawful act manslaughter. We'll talk about how we construct unlawful act manslaughter, sometimes known as constructive manslaughter, and then we will talk about some of the cases that illustrate these points in more detail. So, like I said, we're going to examine the key components of unlawful act manslaughter. We'll talk about the major components of unlawful act manslaughter, and we'll talk about how these are fit together and how this is operationalized in the English law itself. So, some textbooks will refer to unlawful act manslaughter as constructive manslaughter. For those of you who have studied law at A-level and are coming up to university to study law, you will probably be more familiar with the phrase unlawful act manslaughter. However, there are textbooks that will use the phrase constructive manslaughter. So I believe Smith and Hogan use the phrase constructive manslaughter, whereas other textbooks may use unlawful act. They refer to the same thing. Now, in reality, you can essentially justify calling it unlawful act or constructive on the basis of any kind of rationale, essentially, because it is called constructive manslaughter because you construct the manslaughter charge on the basis of a prior criminal act. It is unlawful act manslaughter because it requires an unlawful act for which a homicide can then be constructed on top of. So either way, you can understand why it's called either unlawful act or constructive. The leading case in this area of the law is the case of the Director of Public Prosecutions versus Newbury and Jones. Now, this is a case from 1977, and you can see what we can really get to be the key components and the key elements of constructive manslaughter in this particular case itself. So the facts itself are quite interesting. You have multiple defendants, so there are two defendants. Both are aged 15. And they had been playing around with a paving stone which was left on a bridge by some previous workmen. So they were messing around with the paving stone, and in the process of doing so, they pushed the stone off the bridge. Now, unbeknownst to them, it fell onto another individual, someone who was walking down below, and killed them. It was quite a heavy paving stone, falling at relatively, probably terminal velocity. The blunt force trauma would have killed this victim. Now, they were both convicted of constructive manslaughter, of unlawful act manslaughter, but what they did was they appealed on the basis that they did not foresee the danger, and so as a result of which, because they didn't foresee that when they pushed the rock off the bridge, that there was going to be someone down below who was going to get hit by the rock and killed, because they did not foresee that danger, they ought not to be convicted of constructive manslaughter. Now, this argument was then had and went all the way to the House of Lords, where this appeal would be rejected. And the reason why they rejected the appeal in the House of Lords was because this idea of foreseeability, i.e. relevant foresight, isn't a requirement for showing unlawful act manslaughter. So essentially, they argued on appeal, we ought not be convicted because we did not foresee the danger. Well, the House of Lords said, well, it doesn't matter if you foresaw the danger or not. It is not relevant to your conviction whether or not you foresaw the danger. And as a result of which, your appeal was rejected and the conviction was upheld. In reality, all that is necessary for there to be an unlawful act is that there must be that the act itself must be dangerous and that the act itself must cause the death of the victim. So let's think about unlawful act manslaughter in a bit more detail and think about the kinds of components. The first thing is, given the name and given the fact that you construct the manslaughter charge on the basis of a prior unlawful act, there therefore has to be an unlawful act. So it is a construction offence. You construct it on the basis of a prior act, and therefore come to the conclusion of a homicide charge as a result of which. It is therefore necessary that there must be a prior charge to constitute an unlawful act, one which is a criminal offence in and of itself. And this is illustrated by the case of Lamb from 1967, because what this case was a case involving a defendant who had pointed a gun at his friend, and then he tried to pretend to shoot the gun. I say tried to pretend to shoot the gun because even though it was meant as a joke, he in reality did point the gun and did shoot the gun, and the gun did fire and killed his friend, who then is now the victim of the homicide. The gun in question was a revolver, and he had mistakenly believed that the bullet was not in the chamber that he was firing from. So, for those of you who don't know, a revolver is a type of handheld gun, where you have essentially a spiral whereby there are bullets in each of the different chambers, and as you fire the gun, it switches to the next chamber. And so this is where you get a lot of various different games, like Russian roulette, for example. If there is no bullet in the chamber that is cocked to the point at which you're going to fire from that chamber, then there can be no bullet to fire from. So if you have no, which is why when you play Russian roulette, if you play Russian roulette, you put one bullet in one of the chambers, you spin it round at random, and then you essentially play a test of faith as to whether or not you are going to shoot yourself in the head. So he did not believe that there was a bullet in the chamber that he was firing from. Now, the constructive offence, which was built here, was the crime of assault. Now, we're going to get to assault in a future lesson's time, but assault essentially involves the apprehension of harm that is done to a victim. And so as a result of which, you can then take the crime of assault, which is the constructive offence, and then you can therefore construct further the unlawful act manslaughter on top of the crime of assault to get the offence of unlawful act manslaughter. Now, the reason why this was ultimately quashed was because the crime of assault requires a certain mens rea. Okay, it is not just the actus reus, which is the apprehension of harm, but there is a mens rea element as well. There is an intentionality that is required for the crime of assault. And so, because there wasn't this prerequisite mens rea for the crime of assault, it could not be shown that this constructed offence existed, this unlawful act in which we are constructing the manslaughter existed. So if there was no unlawful act, then therefore the conviction of manslaughter must be quashed, because of the fact that you can't construct manslaughter on the basis of it on an unlawful act if that unlawful act can't be shown to have taken place either. Okay, so that's why we see in this case that the unlawful act is very important to be shown and to be proven quite substantially before you then go on to looking at other charges, i.e. on the basis of manslaughter. In the case of Crown versus Church from 1966, we see a fight that takes place between the defendant and a victim. During this fight, the victim would get knocked unconscious. The defendant, D, believed that they were killed in the process of the fight and not merely knocked unconscious. So they had a fight, the victim was punched or fell to the floor and banged their heads, and they were knocked unconscious. The defendant thinks, oh my god, I've just killed this individual. And so as a result of which, the defendant, believing he had just killed the individual, decided to dump the body of the victim in the river, the still alive body in the river, believing her to be dead. Now, the act of doing so would ultimately lead her to die as a result of drowning. Now, the argument that was presented here, the sort of the legal question that was had, was the idea that was presented by the defendant, among other things, that was that essentially because he believed she was already dead, the act of throwing her into the river could not have been seen as a dangerous act, since there was nothing dangerous about throwing a dead body into a river. Remember, the unlawful act itself has to be a dangerous act, because ultimately the construction of manslaughter through the unlawful act implies that the unlawful act itself can give rise to the death of an individual. Okay, so things like assault, things like battery, things like grievous bodily harm, in some cases even things like theft that goes awry and causes offences. And causes damage to another individual physically. You can't, for example, have an offence such as I'm trying to think of one, such as maybe fraud, for example, as considered to be a dangerous act, and then therefore that leads to a constructive offence of manslaughter. So the act itself that is unlawful, it should be dangerous, because the act itself has to cause the death of another individual. Now, the defendant, like I said here, presented the view that because he believed she was already dead, the cause of death was not the victim being knocked unconscious. The cause of death was the defendant throwing the victim into a river. And so we have to analyze the question of whether or not the throwing the body into the river was considered to be an unlawful act or a dangerous act. And he argued that, or at least the defense argued that, it can't have been a dangerous act because there's nothing dangerous about throwing a dead body into a river. Even though she wasn't dead at the time, the defendant believed that she was. Now, the court said the following in making a decision. They said that the unlawful act must be such as all sober and reasonable people would inevitably recognise must subject the other person to at least the risk of harm resulting therefrom, albeit not serious harm. Okay, so there is a requirement here that harm is created to essentially levy this as a dangerous act, albeit not necessarily serious harm. Okay. The final thing, therefore, is that you have to have we have to have an unlawful act. You have to have that act be committed. So things like assault, if there's no mens rea for assault, then it can't be considered to be a constructive manslaughter. The act itself must be dangerous, and then the dangerous unlawful act must be the cause of death. This is the final requirement. Provided that you can show that the defendant has committed an act which is both unlawful and dangerous, then that act must be the cause of the victim's death in order for constructive manslaughter to be operationalized. Now, the key issue here relates not to the fact that the defendant causes the victim's death, but that it was the very specific acts which were unlawful and dangerous, which were committed by the defendant, which causes the death of the victim.